Hello, welcome to my channel, where I'll be discussing some of the common issues in digital entertainment law. My name's Ryan, and I will be your guide on this magical voyage of imagination and lawsuits. Today, we'll be discussing video game law. So, to really understand some of the common issues in game law, it's probably easiest to start with a hypothetical where you imagine you're a developer. Specifically, imagine that you're a developer with a game called The Cupcake Saga. Justin Bieber spends $1 trillion on cupcakes. Like any good game, this game has an in-game story, which is that in the future, a robot version of Justin Bieber realizes that the secret to happiness is buying and eating as many cupcakes as possible. So, much like Candy Crush Saga or Bejeweled, this game employs a match 3 mechanic where different cupcakes are matched in order to get Robot Justin to spend as much money on cupcakes as possible. In terms of monetization, game points can be exchanged for real-world discounts at nearby cupcake shops, with the developer taking a percentage of each sale. At the end of each level is a cupcake eating challenge, where Justin eats as many cupcakes as possible in a competitive eating contest. The game is a huge hit, and after a year, Selena Gomez releases her own apple eating game with very similar mechanics to the challenge level in the Cupcake Saga. So keep this hypothetical in mind, since we're going to return to it once we've had a chance to discuss a few of the most common issues in video game law and see what issues we can spot later on. So now that we've finished our hypothetical, let's get to the areas of video game law where most developers run into the most trouble. And that really begins with the Child Online Privacy Protection Act, otherwise known as COPPA. COPPA was created to prevent developers and people in general from getting personal information from children, because obviously it's kind of creepy to take personal information from kids, especially information that can be used to stalk them in real life or track their activity online. I won't get into all of the specifics of what COPPA requires because that's a topic for another lecture, but I will talk about how developers often get themselves into trouble with COPPA because it's a much bigger issue than most people realize. So the first area where developers run into trouble often arises because they think COPPA doesn't apply to them because their game or app isn't aimed at children, which is exactly what Yelp thought, since their service is largely dedicated to things like finding the closest pizza place at 1 a.m., and children under 13 generally don't go out that late. That was, of course, until the FTC made Yelp pay a fine of $450,000 for violating COPPA. In their summary of their case, there were a few facts that the FTC really focused on. The first was that Yelp had a sign-up page where people put in their age, but even if you put in your age as 12 years old, you'd still get full access to Yelp, and Yelp would still collect data on you, like GPS data so they would know where you are, and mobile device ID data, which could be used to track a phone's activity online. So basically, even though Yelp isn't aimed at kids, the FTC still issued them a fine because they were collecting identifying information about children. Another reason that developers tend to fall into trouble with COPPA is because they don't think they're liable for the acts of third parties, which was the case with Retro Dreamer and LAI Systems, who made games for kids but didn't personally collect data on those kids. However, the ad networks that they use that run ads in their games, those did collect information on kids. Consequently, the FTC fined Retro and LAI $360,000. Why? Because they hadn't obtained consent from parents for the activities of their ad networks. Small companies aren't the only ones who get hit with COPPA either. Disney had a subsidiary that built a series of games that allowed kids to create their own personal profiles, which included name and location info, without first getting permission from parents. They also had a quick cut and paste for their privacy policy, which didn't cover all of the types of data that the games might collect. So basically, even if parents gave permission, it wasn't clear that those parents would even truly know what they were consenting to. The result? Disney was ordered to pay $3 million in fines. So COPPA is the biggest area where developers usually run into trouble. The next largest area is intellectual property infringement, because there's often a question in video games about how far copyright can extend when it comes to similarities between games. So one of the first cases on this point was Data East versus Epix. Data East had a game called Karate Champ. A few years later, Epix came out with International Karate. To say that the games were very similar would be putting it mildly. Here's a list of all of the similarities that the court found between the two games. Nonetheless, the court found that the similarities didn't really matter, since it was inevitable that both games would overlap in a large number of ways, since both games were about the sport of karate, which was firmly in the public domain. So in the hypothetical where Selena Gomez has her own apple eating game, her game could be defensible under Data East versus Epix, since it deals with the general sport of competitive eating. However, as with everything in IP law, that conclusion isn't so certain, which brings me to my next point. So obviously, when it comes to video games, it's essential to talk about fair use, which is the most common defense to copyright infringement in the gaming industry. There are many different forms of fair use defense, all of which have their own multi-factor based tests. However, discussing all of the various fair use factors would take too long and is the topic of another video. So instead, I'm just going to focus on a fair use defense called parity, which is the key fair use issue in the hypothetical. So to illustrate one of the main principles of determining whether a game or artwork qualifies as a parody or satire, I'm going to take two famous cases where parody was claimed as a defense. The first is Mattel versus Forsyth, where the plaintiff, Mattel, owns Barbie, and the defendant, Forsyth, was a photographer who took Barbie dolls and photographed them as food and or in sexual positions. Mattel sued for infringement. Forsyth claimed parody. The second case is White versus Samsung Electronics. The plaintiff, Vanna White, hostess of the Wheel of Fortune, the defendant, Samsung, created an ad to sell VCRs that featured a blonde robot next to a game board similar to the one used in Wheel of Fortune. White sued Samsung for infringement. Samsung claimed parody. The court found that one of these cases was parody and the other was not. Can you guess which one was which? The answer is that Mattel versus Forsyth is the case of parody. There were several reasons for this, but one of the big ones was that Forsyth's primary aim was to attack Barbie by conveying her in a highly demeaning and unconventional manner, whilst in the White case, Samsung's primary goal was to sell VCRs and not just mock Vanna White. So at the end of the day, if you're going to engage in parody, you should be very clear that your primary goal is to mock your target and not just use your target to sell VCRs or other consumer products. So that brings us to our final area that developers often face trouble in, which is on trademarks. And the best example for the hypothetical that we created at the beginning of this presentation is based on the producers of Candy Crush Saga, a company called King, and their recent activity to protect their trademarks. So in the first example, King holds the trademark for the word saga in video games and other software based on their Candy Crush Saga video game, which then allowed them to block the trademark application for a game called The Banner Saga about Vikings. They were able to do this even though there's almost no chance that any consumer would confuse a game about candy and a game about Vikings. Second example, indie developer created a game called Candy Swipe, which was released 2 years before Candy Crush. However, because King wanted a monopoly on games with the word candy in the title, King bought another game called Candy Crusher, which predated everyone, and then attempted to use that game to block Candy Swipe's application. Third example involves a suit by King against a Chinese developer who created a clone of Candy Crush but with cookies. While I haven't seen the filings yet, presumably the Chinese developer's argument is going to be that Candy Crush itself is a clone of previous games like Bejeweled, which used jewels or other objects instead of candy, and thus King should not be able to sue them for IP infringement. So now let's return to the initial hypothetical. Hopefully, now that we've had a chance to review some of the common legal issues in games, some of the potential problems with our Bieber Cupcake Saga game should be a bit more obvious. For instance, there's a risk that Bieber could sue, just like Vanna White sued Samsung. And while it may be possible to defend against such a suit by arguing parody, it's not so clear that such a defense will work. Additionally, there's a potential that because the game uses location data to find nearby cupcake stores, and because the game is clearly for kids, that there could be an issue with COPPA. Additionally, King could block any trademark application and possibly sue for IP infringement. Finally, as discussed previously, Selena may be in the clear depending on the nature of the similarities between her game and the Cupcake Saga. These are just a few of the issues with our Cupcake Saga game. There's plenty more, but I don't want to give them all away and spoil all the fun. So if you can spot some of the other issues in our hypothetical, feel free to write those issues down in the comments. And thanks for watching.